Alex here with part 84 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal in chronological order. We left off in part 82 with what I believe was my ex parte motion. Well, I didn't call it that. I called it an application to reduce my ex's arrearages to a judgment. And here we are, following the judge's order striking my request for submission, basically saying he's not going to consider it ex parte. He wants my ex to be able to file an opposition if she'd like to the motion. That's where we are right now, and I actually got this idea from that order from the judge. So I mentioned in the previous video that I was not going to be able to execute on those arrearages without a judgment some certain. Even though the judge said that my request was superfluous, he was wrong. I would need a judgment some certain or the clerks would not issue the writs. However, what he did mention did give me the idea to ask for a debtor's exam. Interestingly enough, I don't need a judgment sub certain to get a debtor's exam. I do just need a judgment, and I figured I would kind of use his own words against him, and instead of waiting to ask for a supplementary or for a debtor's exam, which is known as a supplementary proceeding in aid of execution. It's kind of a long wordy phrase for pretty much anything that you're trying to do after you get a judgment to get your money. Anyway, my idea was instead of waiting, I could just kind of use the judge's own words against him and ask for it now, because I didn't need the clerk to do that. That was something that the court would order. So we're about to go into my filing, and in fact, I suppose at this point the best thing we can do is actually go ahead and take a look at what I have filed. Here we have the motion for supplementary proceeding in aid of execution. This is what I was referring to earlier. It's my attempt to ask the court to allow me to examine my ex as a judgment debtor. I'll talk a little bit more about this towards the end of the motion, just in case people are wondering. In fact, actually, I'm not going to do that because I have a video dedicated to the topic. If you'd like to learn more about supplementary proceedings in aid of execution, please watch my video, Execution and Asset Seizure. I go into all of the generalities and the purposes behind it in that video. In the first paragraph, we see the standard introductory statements that I'm identifying myself as the petitioner. I'm appearing in proper person, which means I'm representing myself. And in the next paragraph, going to the factual background, I indicate that another summary paragraph here where I and my ex share a common minor child. We share, the next assertion actually is the one where I go into the physical and legal custody, which is shared between us jointly. The next assertion after that is that the court entered its most recent order regarding child support on May 10th, 2012. Next assertion after that is my letter seeking enforcement of the order. And the last assertion, at least in the factual background, is that my ex has paid $77 towards $183.23 in arrearages. Now we go into the argument. Pursuant to the law, and at this point, it looks like I'm talking about the letter that I sent my ex. Yeah, this is the exact same statute, the statute that covers enforcement. Next assertion here is that I have attached the USPS return receipt indicating my ex received the letter and that I satisfied the requirements of the aforementioned statute. And it's my ex's obligation to ask for a hearing, and I think I mentioned that she hasn't done, yeah, right here I mentioned that she hasn't done so. And then I go into the next statute, and this is the statute that I used against the judge, because this is a statute that he used in his order striking, which is that under the law, payment for support of a child or an order requiring payment for support of a child becomes a judgment by operation of law on or after the payment is due. So what I'm stating here is that, yeah, you're right. This does give me the judgment that I need. Technically, it's not something that the clerk can enforce because there's no judgment some certain, but it is something that I can use for other purposes. And here I go into my conclusion, effectively asking effectively asking the judge to allow me to conduct a debtor's exam under NRS 21.270 subsection 1A. And that's the only thing really that's different in this document from the previous one that we went into, and that's the application to reduce my ex's arrearages to a judgment. This is the one new thing that I cite, and this is the law that allows a judgment creditor to examine a judgment debtor. And it basically, in a nutshell, involves asking questions to find out where their assets are so that you can then seize those assets. Again, if you want all of the details, watch the video Execution and Asset Seizure. Affirmation, which is the statement that lets the court know that I've reviewed this document and that it does not contain a social security number. Declaration, we've gone over these before. It's basically me swearing under penalty of perjury that all of the facts alleged in this paper are true. And we have Rule 5, Certificate of Service, indicating that I personally served this motion upon my ex's attorney, which means I took it and physically handed it to the lady working behind the desk at her law office. Here we have a motion opposition notice. This is what I was wondering as to, why it wasn't included in the last two filings. Usually the clerks will reject a filing if I do that. Anyway, this is going through a process where you check some boxes and find out whether or not you need to pay a $25 filing fee. I'm sure the amount has increased by now. This was years ago. It was just $25 back then. In any event, based on the boxes that I checked, I do not have to pay a filing fee. Moving on to the request for submission. Here we have me indicating to the court that this motion for supplementary proceeding can be submitted to the court. Why is this being... Hold on a second. Yeah. Okay, so once again, it looks like I'm not waiting for my ex to have an opportunity to respond. I know why I'm doing this, even though it's not right. So the reason why I'm doing this is because when I worked in collections, we didn't wait for the opponent to file an opposition. We just filed a motion for supplementary proceeding or debtor's exam, and the judge or the justice of the peace, because it was typically justice court cases, would almost always just grant it. They wouldn't wait. And so perhaps at the time that I did this, I assumed that it was going to be the same in the district court. In all honesty, it's probably that the district court, I doubt that he's going to consider this without my ex's opposition. But what I wanted to say is, I doubt that the justice court was doing it right in the first place. I feel like in hindsight, looking back, even though the district judge, in this case, I haven't checked yet, but I'm pretty sure he's going to strike this request for submission and allow my ex to oppose this too. I'm pretty sure that the way he was doing it is actually the way that it should be done, and that the justices of the peace in the justice court should probably wait to allow the opponent an opportunity to file an opposition or something like that. But for whatever reason, I didn't really understand that, and I assumed that since that's how they do it in the justice courts, that's probably how they were going to do it in the district court too. Again, I'm not sure yet. I haven't looked into the future. For all I know, this isn't a problem, but I suspect that there's going to be an order striking that's going to be coming after this filing, to just allow my ex to file an opposition. I'm going to just double check one more time. This was filed on June 13th. 1 second. Oh, never mind. Okay. So this was unopposed. So everything that I just said, scratch that. In fact, it states right here, respondent did not file an opposition. Okay, never mind, guys. I did give her an opportunity to file an opposition to my motion for debtor's exam. She did not file an opposition, and after the time lapsed for her to do so, I submitted the matter to the court for decision, which is the correct way to handle that. I'm not going to edit out all of that stuff that I mentioned, because all of that stuff that I mentioned about how the justice courts handle that and how I waited in the district court, it's all true. Sometimes different courts do different things that aren't necessarily consistent with the rules, and I still feel like it's a little piece of my mindset for the viewers that could actually be helpful. So even though that didn't actually apply here, even though I did give my ex an opportunity to file an opposition, I'm still not going to edit it out. Hopefully you guys get a little bit from that. Going on to the consent to electronic service. Okay. This is me trying to consent under a specific rule of civil procedure to allowing my ex's attorney to serve me electronically. I have a tiny story. I want to say tiny because it wasn't even really that big of a deal. But when I submitted this and I told my ex attorney that she could send me stuff electronically if she wanted to, she refused to do it. She would keep mailing stuff to me. I think that some family attorneys don't really follow the rules so much. If there is a rule that nobody really uses in the family law industry, they'll just treat it as if it's not a rule. And so I brought this up to her and I said, hey, from now on you can just serve me by email. This is a rule that allows it. And she said, nah, that's not a rule. And I'm like, yeah, it is. But then later on, years later, I started to realize maybe with a lot of the family attorneys, the sort of approach they take is we don't care if it is a rule. If none of us does it, then it's just not a rule to us, and so we won't honor it. They kind of have this sort of conveyor belt approach to these cases, and if your tool or technique or approach doesn't fit onto that mass production line, it's a foreign alien creature to them, and they don't care if it's allowed or legal, or it's just nobody does it, so to them you're weird for trying to do it. And that's kind of what I feel now in hindsight she probably felt with regards to this consent to electronic service. Basically, since nobody uses this, she wasn't going to honor it. Here's the affirmation pursuant to, well, we've gone over this before. It just lets the clerk of the court know this document does not contain a social security number, and then another Rule 5 certificate of service. Going into the aftermath, I filed 1, 2, 3 documents, but they were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex's attorney would have probably spent very little time on this. I imagine she at least contacted my ex, maybe by email or by phone. And since she didn't file an opposition, I guess I can kind of lump all of that consultation time into this sort of video. So let's go ahead and put the motion that I filed at 25 minutes. And then let's put the request for submission and consent for electronic service at another 5 minutes lumped together. We reach a total of 30 minutes, which at the rate of $250 an hour is $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.